We're going to go ahead and get started. It's 2 o'clock. Welcome back for week 6 of our 10-week training series. My name is Denise Nerby. I am the Tribal Justice Manager at AVCP in Bethel. I hope you're all doing well and staying warm. We're getting close to Thanksgiving, so I hope everybody is getting the chance to get together with family, even in a safe way for the pandemic. To get started, though, as always, we're starting with our housekeeping reminder that these trainings are being recorded and we're all placed on mute to begin with. Presenters, if you're on the phone, you could press *6 to unmute yourself, or on the computer, the microphone button at the top right-hand corner of your screen. We're asking that everybody remain muted unless speaking, but we very much welcome any discussion or questions that you might have. Today, we're going to hear from Kevin Illingworth, who is a professor of tribal governance with UAF, Rick Garcia, who is a tribal court facilitator at the Alaska Native Justice Center, and Judge Deborah O'Gara, who is the senior policy specialist with the Alaska Native Women's Resource Center. They will be speaking toward the topic of removal and banishment. So without further hesitation, I am going to share my screen and hand the time over to Kevin.
Thank you very much, Denise, and welcome everybody. For today, we are going to be talking about removal and banishment in tribal court. I really want to start off acknowledging these are very similar subjects, and we're going to be trying to talk about these to explain a little bit of the difference in strategies of whether you move forward with a removal or whether you move forward with a banishment in your tribal court. So we go to the next slide, please, Denise. So we're going to talk about removal and banishment separately as if they're two different things. I want to be clear, we're talking about the same thing, removing somebody from your community. The reason we're talking about these separately is because of the tools that you have at your disposal, whether you call it a removal under the Violence Against Women Act, or whether you call it a banishment under your inherent tribal authority. So I'm going to start kind of backwards with what I said, a banishment. I know this term is very loaded and means a lot of things to different people. When we will use this term today, banishment, what we're going to be talking about is removal of somebody under the inherent tribal authority, where it is up to the tribe to enforce this removal. So if we call it a banishment, it's up to the tribe to enforce that banishment. If we call a very similar action a removal under the Violence Against Women Act, what the Violence Against Women Act does is gives your tribe authority to order state law enforcement to do something, which can include arresting or removing somebody from your community. So we're going to go talk about these two things in some detail today, and hopefully have a lot of time for questions to try to figure out what's the difference between the two. And then for all of you, you're going to have to, in every situation, think about, should we be doing this as a banishment under tribal authority or as a removal under VAWA? And next slide, please.
Okay, so banishment versus removal, what is the difference? I think we all know, but sometimes it's helpful to put things in words. Banishment of tribal citizens, it remains an exclusive tribal remedy and the tribe's right to perform. States, including the state of Alaska, cannot banish individuals from tribal lands and villages. In fact, the previous Attorney General Lindemuth in 2017 said that tribes are sovereign and banishment arises between a private person and that particular sovereign. So Lindemuth also said that tribal governments are looking for ways really to improve public safety in remote villages that often have no law enforcement at all. So when we talk about banishment in Alaska, in recent times, we've seen banishment orders come from tribes such as in Sand Point, Emonic, Alakanuk, Nunam-Ikwa, Quinahawk, Akiak, Alakahit, and also Togak, which Kevin's going to go in more detail later. Some people have been banished in multiple communities, and some communities have also banished multiple people. We all know that banishment is the traditional form of punishment, and it's used to prevent an undesirable person, for lack of a better term, from remaining in a specific village or other tribal area. The punishment can be broad or it can be limited in scope, preventing a person's access to either a specific part of a community or even an entire village. And banishment orders have been issued for either a short period of time or for a very long period of time. When we talk about removal under VAWA, there are specific provisions in VAWA, and there's a full faith and credit provisions that require all law enforcement officers to enforce a valid and non-expired tribal DVPO as if it were issued by a state jurisdiction. So in Alaska, what that means is that all law enforcement officers are required to treat tribal DVPOs, where VAWA removal would come into play, as if they were issued by an Alaska state court judge. I think it's important to note when we're talking about removal under VAWA that VAWA doesn't define domestic violence, but it specifically points to the tribal definition to define what tribal law is for domestic violence. So your tribal codes are going to define what tribal law is and what domestic violence is under VAWA, and that will be applicable under the full faith and credit provisions of VAWA. Next slide, please. Okay, so the language we use matters. Why? And I want to be politically correct. We are dealing with a sovereign, and that is the state of Alaska, that really places an emphasis on words rather than what the intent of our orders are. So under Alaska state law, banishment is unlawful. It violates not only the Alaska Constitution, but it's been found to violate portions of the United States Constitution as well. So when we're applying it to the state of Alaska is not going to enforce any banishment orders if we use that word banishment. But because of the VAWA provisions, a temporary removal can be okay. So the state of Alaska has really elected to maintain a hands-off approach to banishment because, again, it's deemed to violate state law. And again, John Linda Moose, the previous Attorney General, said that banishment is a traditional form of tribal justice that is processed within the tribe as a private civil action over which the state of Alaska has no authority. So I think it's important to note also that the state of Alaska, the Department of Law, has really issued 2 memos regarding enforcement under VAWA. The first was issued in July of 2015 by then Attorney General Richards. And I want to say I've read through it. I'm sure a lot of people have read through it. It's a really convoluted memo that talks about VAWA, tribal jurisdiction, and the full faith and credit requirement under VAWA. It may be a good read, but again, it's convoluted, it's confusing, it's not to the point, but if you want to read it, I'm going to put the opinion in the chat. Just be aware that it may be easier to read the second one, which I'm going to talk about right now. In 2017, the Department of Law issued a second memo that was issued by Deputy Attorney General of the Criminal Division, Henderson. And what that memo provided was a great 1-page memo to all Alaska law enforcement personnel on enforcement of tribal DVPOs under VAWA. And so some of the highlights of that were that all protective orders issued by a tribal court are entitled to full faith and credit and enforcement under VAWA. Secondly, that the filing of a tribal DVPO with the Alaska court is not necessary. And then it listed some required elements that we want to make sure we're thinking about when we're putting in our tribal DVPO so that we will have the protection of VAWA. And that is quite simply that it must identify the petitioner and respondent, must contain articulable provisions intended to prevent violent or threatening acts, harassment, sexual violence, contact, communication, proximity to a person, or stalking. And then the third one, which I think is important, is that the order must appear authentic. They don't give any direction on what that means, but essentially law enforcement officers are not to investigate beyond looking at the order itself. If there are any questions on jurisdiction or due process, that needs to be addressed by the prosecutor or an Alaska state court. So I've placed both of those links into the chat, and I can certainly send them to Denise to share with everyone. The second one I think is more helpful when we're talking about language and using how it matters under VAWA. Next slide, please. Okay, so again, the language you use does matter. So again, banishment is a traditional form of punishment used to prevent an undesirable person from remaining in a specific village or tribal area either for a specific period of time or for a longer period of time. So when we talk about banishment versus temporary or longer removal, the language matters. And again, particularly when we consider whether the state of Alaska and law enforcement is going to assist tribes with enforcement, we want to make sure that we're thinking about the language that we're using to make sure that we get a broad range of enforcement. If tribes have their TPOs or VPOs available to enforce, and we want to enforce that within our villages or tribes, then language may not be as important. But if we are seeking state enforcement and assistance, because of the way that the state of Alaska treats language and the emphasis they place on certain words and orders, we really want to think about what type of language we want to use to really achieve the broad purpose of what our tribal orders are saying. Next slide, please.
Okay, thanks, Rick and Kevin, and good afternoon, everybody. So, as Rick has just said, language matters. So, if you, the tribe, want somebody to be removed from, and you want some help from the local non-tribal law enforcement, and you want them to be removed from the village, you need to use the word removal. And it's the word removal that is actually used in the federal statute, Violence Against Women Act, that allows the state troopers and other municipality law enforcement to enforce the removal. Now, the word, not only do you need to use the word removal instead of banishment if you want outside help to enforce it, it also needs to be part of, in order to come under the federal authority in VAWA, you also need to have that removal order be part of of a domestic violence protection order that has, and the reason for the removal has emerged out of a domestic violence situation. Next slide. And some of this might be repetitive from previous, I've lost track of what we've already done and what we're going to do. I know we're going to be talking about protective orders, and so this slide is going to be a little bit repetitive of something that we've already either covered or will be covering. But real briefly, in order to do a tribal protective order for domestic violence that is enforceable under VAWA, and again, tribes have the authority to do these and enforce them yourselves. But if you want your protective order and the removal to be enforced by outside forces, then you need to hold a hearing. There needs to be notice to all the parties, including the person who the order is going to be against. And there needs to be a decision maker who is impartial or fair. Now, you do have the opportunity to have what's called an emergency hearing in order to get an ex parte order. All that ex parte means is the judge or the decision maker only hears one side of the story, doesn't hear both sides. If you do have an emergency or an ex parte order, it normally is only good for a short period of time, 10 days, and then there's got to be a hearing where the respondent or the person who the order is going to be against then has been given notice and an opportunity to appear at a hearing. At that second hearing for the longer term protection order, then both sides have an opportunity to give their side of the story of what happened. The petitioner gets to then tells the judge what has happened through testimony and or witnesses and evidence, and then the person who the order is going to be against, who often is called the respondent, is given an opportunity to defend themselves or argue against the protection order. So all of that, those processes right there are all called due process. And for those of you who work in the court system, you will hear the term due process lots of times, and it essentially means only three things: notice, opportunity to be heard, whether the person appears in court or not, they have an opportunity to actually be there, and a fair or impartial decision maker. And the opportunity to be heard means that they need to be told when the hearing's going to be, and they need to be given a way of participating in that hearing. And certainly in this COVID times, that often is either over the phone or through Zoom, as courts are mostly doing online or video conference hearings, and those are fine too. And then just the last thing, in order for the protection order to fall under VAWA and be enforced by under that for removal, then the order for removal needs to be connected to the protection, to the offense of domestic violence. And as Rick already said, VAWA doesn't define domestic violence. Your tribal law defines domestic violence. So it can be whatever definition you set out, which can be different from your neighboring tribe, and it can also be different from the state definition of that. So, and then of course, protection orders also need to be specific with names, birth dates, identifying marks, etc. So again, we've got slides and information that's going into greater detail on that. So next slide, please.
Okay, thanks, Deborah. So in addition to the 2015 Attorney General memo and the 2017 memo that we talked about, in 2014, the Attorney General Garrity also stated that the state of Alaska has recognized and enforced tribal court protection orders since at least 2008. And it also goes on to talk about the troopers' efforts, and it states that the troopers' efforts are going beyond the requirements of VAWA governing full faith and credit. That was issued back in 2014, and I don't think I would be in error saying at this time, we all know that enforcement of tribal DVPOs under VAWA, it can vary across the state, right? We know that enforcement in Western Alaska may be different on how these are enforced in Anchorage or enforced in Fairbanks. And it's different statewide because there's a lack of clear policies on enforcement and what that means. And I will tell you that from a recent conversation, I think it's okay that I share this. If not, I'm sharing it anyway. In a recent conversation that I had with state troopers and trooper leadership, their definition of enforcement under VAWA is arresting authority, right? And that shouldn't surprise us at all. The state is really looking to prosecute on the criminal side anybody who violates a domestic violence protective order. We know from a tribal perspective that we're not so concerned with arresting somebody. We just want to make our tribal citizens and our tribal members safe. So when we think about enforcement, again, some best practices are going to be how we're crafting that language and making sure that we're thinking about where we're going to need to get that assistance and enforcement from. I want to tell you more about my conversation with troopers, but I don't think it's finalized yet. But there are some upcoming things that may be really helpful for tribes to get their DVPOs enforced in a better way statewide. And so I'm really looking forward to continuing this conversation with trooper leadership on that. But essentially, the 2014 memo that we see on the screen, the 2015 memo, and the 2017 memo all really solidify the troopers' policies within Alaska that they are supposed to enforce VAWA under the full faith and credit without any registration requirements, and they should be enforcing it uniformly. And I'm going to turn to Deb and Kevin to see if there's anything to add to that slide.
No, do yourself a favor though, and just read the short one. Read the 2017 one. It's much easier to read and very straightforward.
Oh yeah, again, the 2015 one is really confusing, so I agree with Deborah.
And Rick, I just really appreciate how you said that both you define what domestic violence is, and that also we have inconsistencies in our state. They should be consistent, and hopefully that'll work out.
Yeah. Okay, next slide, please.
Okay, I know we've sort of covered this again, but this is an important enough thing because banishment, removal, who's going to enforce it, all of that stuff is really confusing, and especially with our law enforcement, whether it's tribal law enforcement or state law enforcement or municipality, you know, whether it's Juneau or Nome or Anchorage. There's as many people as you're going to ask. There's that many opinions and beliefs in what it is. So we just wanted to highlight banishment, as I think Kevin or Rick said at the very beginning of this presentation today, has been used by tribes throughout Alaska since time immemorial for very severe, not always violent, but certainly severe, and cases where there was usually no other recourse to keep the community safe. So banishment is nothing new. Banishment / removal is really nothing new to us. We've had incidences of that throughout our thousands and thousands of history up here in Alaska. And it comes under our inherent tribal sovereignty or authority that has never been extinguished. And so VAWA comes along and doesn't necessarily mention it. And so the reason why we are forced to say that if we use the word banishment, it's not going to be enforced under federal law, or for that matter state law, doesn't mean that we don't have it. And I think that's probably the most important message. Just because the federal government or the state government does not recognize tribal right to banishment does not mean we can't do it, or our tribes can't do it. So, and the right to banish somebody from our community does come under our inherent sovereign authority to protect our communities and our citizens. Now, of course, and there's a little paragraph on this slide, and I know you all have the slides and you can read this. Some of the confusion is not just the state law interpretation of the word banishment. Some of it is the lack of quote Indian country tends to confuse folks, as well as now the new term I'm just hearing a lot of this week with the White House summit is in tribal lands. So they essentially, I think, mean the same thing. But it's just important to remember that banishment is a tribe's right if it chooses to exercise that right or to continue exercising that right. And if it's something that the tribe does want to exercise, I would just add that if you are going to do written laws, think about adding a provision in your laws about banishment and or removal, just to be clear. But that's, again, not required. It's just helping to put folks in your community on notice. And then there's, about all of this, there's a good example, which I'm going to turn over to Kevin for this, and he's going to talk about his own experience with the Togiak case, which I think is for the next slide.
Yeah, we'll hold here for a second. Thanks, Deb. Okay. I do want to make clear that this is not controversial. And if you could go back just really quick, Denise. We talk about banishment in Alaska as if it's controversial because the state of Alaska doesn't like it. This is not an issue anywhere else in the United States. I just want to be really clear. Federal law is very clear when we're talking Indian country and reservations. Tribes have the ability to exclude, to banish, to remove anybody they want from their lands. This issue is confusing in Alaska, here in Alaska, because Alaska wants it to be confusing because they don't want you to do it. We're here to say you clearly do have this authority. Now, even though the state of Alaska doesn't want you to do it, they're pretty powerless to stop you. And that's really where this next case comes in. So we had a situation in 2019. It's called Ortwich versus Togiak. I'm going to talk a little bit about this case because this case demonstrates what happens if you do a banishment on your own and somebody challenges that. Now, I'm going to tell the facts of this case. This is a very extreme case. I'm not saying go out and do this, but I am saying you're within your rights as a sovereign nation to do this. So Ortwich versus Togiak. Ortwich was a non-native, so he was a white guy, and he owns the Airport Inn in Togiak. The Airport Inn is a little hotel. It's located on the airport in Togiak. Togiak is a dry community under both state law and tribal law. They passed a local option saying it was dry, and they passed a tribal law saying it was dry. But like many non-natives, this guy Ortwich felt he didn't have to follow the law, and he continually brought alcohol into Togiak to sell at his establishment. He also bootlegged this alcohol and would sell it to people in the community. This went on for years until eventually Ortwich bootlegged and sold alcohol to some kids, and these kids got hurt, and the community had enough. And they said, we're done. We know you bootlegged, we know you did this, and they banished him. They held a tribal court hearing where evidence was taken that he brought in alcohol, and the tribal court ruled he was banned. Now, I want you to remember a couple things here. First, this was a non-native, and Togiak is also a city. But yet he was banned. His alcohol was seized that he was trying to bootleg in, and he was banished from by the tribal court. This guy, Ortwich, went and got himself a lawyer, and the lawyer said, they can't banish you. You have rights. You should sue them. And they said, just go back. You could go back to Togiak. They can't do anything to stop you. So this guy went back to Togiak. And Togiak police arrested him. And he was placed into the city of Togiak jail because he refused to leave. That's really important. What Togiak tribe was doing was trying to remove this person, banish him. They didn't want to put him in jail. They wanted him to go. He refused to go, so he got put in jail. Every day they said, you need to get on the plane and go. He said no. They kept him in jail for 6 days as he refused to leave. On the 6th day, they said, you have to leave. He said no. They handcuffed him, bound his legs in duct tape, and put him on the plane. Now I pause for dramatic effect there for a second, because obviously that's a big deal, right? The tribe handcuffed this guy, duct taped him. He's non-native. He owns this property. What happens? Next slide, please. So given the extreme circumstances in this case, what does the court have to say? The court concludes that all of plaintiff's claims, so this Ortwich guy sued the tribe and they said all of his claims against the tribe and individual defendants acting in their official capacity as officers and employees of the tribe are barred by the doctrine of sovereign immunity. Goes on to say the Indian Civil Rights Act does not create an implied right of action against the tribes. These claims cannot be pursued in state or in federal or state court because of sovereign immunity. In this case, the tribal court judges were sued. The tribal police officer was sued. The tribal council was sued. Federal court held these suits cannot be pursued in federal or state court. Sovereign immunity bars the claim. See, in that last sentence, he says if plaintiff wants to pursue a claim, he has to do so in tribal court. So if Ortwich wants to sue Togiak, he has to sue Togiak in Togiak tribal court. Now, what about the banishment itself? This is the language that the court said particularly about the banishment. To the extent that this claim is the claim is asserted that the tribe cannot banishment, it cannot be an individual claim. He's saying that he should be able to go after the individuals and sue the council members and sue the judges and sue the police officer. They said he can't. This rests entirely on the premise that the banishment was wrongfully taken by tribal officials. This count is dismissed regarding the banishment. The court held that tribal sovereign immunity barred this claim. Now, this is a huge deal as far as tribes in Alaska are concerned, because whether or not we have clear legal authority to banish somebody, this is the federal court saying you can't be sued if you banish somebody. Every other tribe in the United States has clear authority to do it. You may not, but you still can't be sued if you do it. Our tribal council members, our judges, our tribal officials and staff all have sovereign immunity while acting in their official capacity. Now, for all of you as tribal judges, council members, many of you live in a community like Togiak where there is a city. In this situation, the city and the tribe kind of work together to take care of this situation. The city does not have tribal sovereign immunity, and the city is being sued by this Ortwich guy for violating his rights. This is an example of how our tribes actually have tremendous more authority than our city governments may. And so we really want to strategize, how can we work together so that we could have the shield of tribal sovereign immunity to keep our communities safe. And I think that that's really important. The tribe here was acting to keep their community, their children safe. And taking that action, the sovereign immunity is a tool to protect what the tribe is trying to do. So that last quote on the bottom is just from the Federal District Court, Ninth Circuit, saying that we've held that tribal sovereign immunity bars tort claims against the tribe, and that remains good law. So your tribe cannot be sued unless you consent to that suit. And thanks, Denise. Next slide. So this slide really is meant to be, again, again, the reminder of the difference between removal under federal law, under the delegated authority under VAWA, versus banishment being a removal under the inherent tribal authority that really is up to the tribe to enforce. If you don't have tribal law enforcement, you may not have an officer to go there and remove somebody from your community. Tribes can deputize people, or your tribal council can take that action to remove somebody, similar to how we heard law enforcement do it in Togiak. I'd really like to open it up to Rick or Deb if you have any other comments.
Well, I think Rick was going to explain in just a couple of sentences what sovereign immunity is, because that's a very legalistic term. Yeah,
thanks, Deb and Kevin. Yeah, it's sovereign immunity. It's really derived from way back in the day, British common law, right? And it prevented the idea that private citizens could sue the king for doing anything wrong. So in the United States, it's been adopted. And like Kevin mentioned, it applies to the federal government, it applies to state governments, it applies to tribal governments, but it does not apply to municipalities. So in the Togiak case, that's why a private citizen can sue Togiak, because they don't have sovereign immunity, but he couldn't sue the tribe because the tribe does. Essentially, it means that a tribe or tribal employee acting within the scope of their official duties cannot be sued for actions that are derived from their official duties. So put another way, a tribe in Alaska is exempt from the jurisdiction of 4 national courts, and in this case, it would be the Alaska state courts or even the federal courts, for actions that are derived from either the scope of their employment or because they are a tribe, unless, like Kevin mentioned, they choose to waive that sovereign immunity. I think the great thing about the Togiak case was the federal court said, hey, if you have an issue, go back to your tribal court, right? But how likely is a tribal court to take a case and waive their sovereign immunity for somebody suing them? They have the decision to do so or not. You know, they can do it, they cannot do it. But essentially, so sovereign immunity prevents the tribe or tribal officials from being sued because of the acts of their job performance of their duties.
Yep, and I know this isn't a training on sovereign immunity, but for those of you who get federal grants and stuff or go into contracts with some people, some entities, corporations, or governments, often what's part of the contract or MOU is a waiver or a limited waiver of sovereign immunity, and that is so that if there's any disputes that arise out of that contractual relationship, then one party can sue the other party. But I found this case pretty interesting in that the federal court said go back to the tribal court, but my guess is that even at the tribal court, the tribe would still assert its tribal sovereignty at that forum as well. So there would be no recourse. Not always. It's really up to the tribe whether they waive it or not. Okay. I hope we've clarified and not further muddied up the issues.
So at this point, I would like to open the floor for any questions or comments to our presenters. I know that banishment is kind of a touchy topic, and we're welcoming any questions or comments. If you have hypothetical situations, please unmute yourself and go ahead and ask, or if you have anything to add, please unmute yourself and add. Remember, it's *6 or the little microphone button at the top right-hand area of your screen. I seen Estelle added in the chat. In my village, we amended our tribal constitution to ensure we did not give up our community in any way. So just because we're talking about sovereign immunity, can you speak a little bit about the waiver of sovereign immunity that was proposed by the state in that topic, Kevin?
So yeah, as we start talking about waiving sovereign immunity, I do want to start just by making clear everybody understands we're not talking about waiving sovereignty or your inherent sovereignty, right? We cannot waive our sovereignty. It's inherent, it comes from our ancestors. This tool of sovereign immunity that, as Rick said, English common law, we are asked sometimes to waive. And the state, if we're getting state grants, has asked that you do a limited waiver of sovereign immunity for the amount of that grant. If you do waive sovereign immunity for something like funding, that's okay. Think of it as a tool, but be sure you're only waiving it for the amount of that money. We don't want any broad or accidental waivers of sovereign immunity leaving you open to suit. The good part about the state requiring a waiver of sovereign immunity for any funding, I always tell tribes, this is a state saying you're sovereign. They wouldn't tell you you have sovereign immunity and you need to waive it if you didn't have sovereignty. So they're saying, here, you're sovereign. We recognize that. We'd like you to waive it for this amount of money. Hopefully that's a good explanation, but if anybody has any follow-up questions.
I think that was a great answer. That and I'm just going to ask if there's anybody that would like to add to that.
It's Estelle. Sorry, my voice is just kind of crazy right now. I think that, and to add to that, Kevin, I think that we have to be very cognizant and to be really aware of what the differences between sovereignty and sovereign immunity, especially when it comes to agreements. There are some instances, I think, where agencies might hope that you don't understand that and they're going to ask for something more. So if you still don't understand it, one of the things that I do is to ask for a more detailed explanation, and I want to hear it from their own perspective, what exactly it is that they are wanting us to waive.
So I was just leaving the floor open a little bit for any questions or comments to our presenters. If anybody wants to unmute themselves or add to the conversation in any way.
Well, I'll just ask if there's any tribes that have done removals through protection orders or have done banishment orders, and how have they worked out for you?
And I do want to say it's *6 if you're on the phone. We have a number of participants on the phone. So *6 if you're trying to unmute yourself.
This is Zita Sakila from Malaknak. Yeah, they've done banishments in the past. Are you able to hear me?
Yes.
I can hear you, Zita.
Yeah, they've done banishment for domestic violence and history of domestic violence, and the behavior was not safe. Even the tribal council got threatened. So they've had a banishment with treatment recommendations, and the individual, when completed, can come to the council and request that banishment be lifted. Do you know of any other tribes that have done that, or have any other tribes done this also?
No, but I think that's a great way of ensuring compliance from your people.
Mm-hmm.
Yeah, I agree. And I think it's also a great way of providing due process. There's a way of the person coming back to the tribal court and saying, hey, I've completed this. I want to be let back in the tribe. And that gives that person notice and a process on how that's going to be handled going forward.
And that has happened with tribes here in the interior have issued similar banishments to that, Zita, with conditions that they have to complete and then can apply to have the banishment lifted.
Yeah.
So since we're speaking a little bit about lifted banishments, are you able to talk a little bit about the process that goes into lifting a banishment? So I would say that it would be a court case, a hearing, you know, but just so that people understand what goes into if somebody was banished and they've met the terms of their order, they've gone to treatment, they've gone to anger management, whatever it might be, and then the tribe decides that, okay, they have sufficed their order, what do we do now?
So this is Kevin, just real briefly, in a situation exactly like you just described, it was a younger man who was banished until he completed treatment and had actually had to make efforts to start paying on his child support as well, was one of the conditions. He did, and then he had actually just called up the tribe and said, hey, I did this, what do I do? And they told him, we'll file a petition to tribal court. So they actually filed a petition and did a hearing. He was still located in Anchorage and called into the hearing and just basically provided evidence that he did complete his alcohol assessment and treatment and really wanted to be able to come back. And so through that hearing, the tribal judges decided to lift the banishment and allow him to come back.
And I'll just add that whether it gets done by a tribal court or the tribal council is really up to the tribe to decide, and it can even be a mixture of the two. The tribal court can be the one that issues the banishment order, but then the person who's been banished can petition to the tribal council. So the thing there is, even though, and I think it was me who said you don't have to write in your laws the banishment procedures, but but it might be worthwhile doing that so that you actually go through the process of some of these questions internally in your community. Do you want to do banishment? Who do you want to decide what things, what incidences do you want banishment to be considered for? And then is there any remedy? Are they banished forever and that's it? Or do you want to set out some proceedings or conditions, some possible conditions that somebody would have to meet in order to be able to come back in and have that banishment dismissed? So it's sort of the same with the removal right now. And again, because this training this week is on removal versus banishment, for removal orders that are part of a domestic violence protection order, there's a set time limit. Normally it's 1 year, though I want to add that at least down in Southeast Alaska, there is the possibility in a tribal court to do a 5-year protection order. It just requires a third hearing, which is not an option in state court. But if you have a protection order that has removed somebody from the community, it only lasts for as long as that order lasts, which is often 1 year. And then the removal order doesn't exist anymore. So you'll have to decide if that incident was bad enough to start banishment proceedings.
Yeah, thanks, Deborah. I want to kind of echo what Deborah has said and just add on that, you know, banishment, when we talk about banishment, that's an inherent tribal remedy and a sovereign right of the tribe to do. So if it's outlined in your tribal laws, great. Even if it isn't, you're still allowed to do that. We can rely on traditions and customs for that banishment. And I think that, Denise, to add to your question, I think the most important thing that we need to remember, we should remember or consider doing, is that we need to make sure that we're providing the parties due process, including the person that we are potentially banishing. So if we do that and we go through the 3 requirements that Deborah talked about earlier, then we can be sure that we're complying with the Indian Civil Rights Act. We can be sure that there aren't going to be challenges for tribal court orders. We can ensure that the decision of our tribal court is going to be upheld at any future challenges.
So I was just staying quiet for a minute to make sure that anybody who wanted to add or had any comments or anything could. Just trying to see if everybody's questions were answered. Last go around, does anybody have any questions or comments for any of today's presenters regarding removal or banishment? And if you don't feel like speaking, you can drop it into the chat as well. So
well, this topic usually gets a lot more questions, huh?
I think it's just a very touchy topic. It's, you know, something that I'm not sure if everybody would like to speak about in a group setting. If anybody is interested or wants to ask any questions and you don't want to do it in the meeting today, you can always email tribaljustice@avcp.org, though our server is down right now. We also have you could call us 543-8550, and we're always we're willing to connect you with any of our presenters at any time. So please reach out to us if you have any questions or comments or concerns, anything. We want to help. So with that being said, I'm going to go ahead and end today's meeting, and we would love to welcome you back next week on Tuesday from 2 to 3:30, though like today we may end early. Next week we will speak about ICWA. So thank you everybody for joining. Thank you to all of our presenters. We very much appreciate all of your help all the time.
Thanks, guys. Have a great day.
Thanks, everybody.